Recording.
So the meeting is called to order in accordance with the Open Public Meetings Act. Notice of this meeting was provided to the Home News Tribune, the Star Ledger, and the Highland Park Planet on March 24, 2026, and was posted on the Borough website at www.hpoborough.com and on the bulletin board of Borough Hall, 2021 South Fifth Avenue, Highland Park, New Jersey, and has remained continuously posted as required by law. The fire exits are to the left and right of the council chambers. Please speak into the microphones whenever you have a comment. So let's do the allegiance to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which stands one nation under God, indivisible, with liberty and justice for all. So can we do the roll call, please?
Mr. Dickerson, Mr. Factor,
Present.
Mr. Pheasant,
Here.
Mr. Hofer,
Here.
Mr. Holzapfel,
Here.
Ms. Corbin, Ms. Leslie, Mr. Rothberg,
Present.
Mr. Vining, Ms. Swash,
Here.
Mr. Winfrey, Mr.
Here.
Thomas,
Here.
Mr. Cosenza,
Here.
Mr. Robinson, Councilman Hale.
Thank you. So our first item on, any other comments? Okay. Our first item on the agenda is the memorialization of resolution Z202601.
Mr. Chairman, if I can, members of the board, there has been a discussion that I've had with the attorney for the applicant. They do not really have any substantial issues regarding the resolution. However, they are asking for a consideration with regard to one item, and it happens to be item number 7 in the conditions. That happens to be page 11 if you'd like to go to it. What it now says is that as follows: filtration media deliveries and removals through Cedar Lane will occur only during normal business hours of 8 a.m. to 5 p.m. Monday through Friday, excluding legal holidays except in an emergency. It has been suggested by the attorney that in fact their normal business hours are actually from 7 a.m. not 8 a.m. to 5. I indicated to them that I thought this is a matter that I didn't feel as though I had the authority to change, and therefore he indicated to me that a representative from Middlesex Water would be here. I believe that, don't look around, you're the guy, that he would explain the situation, and you will ultimately decide whether or not the change is in a sense relatively minor and can be done tonight or otherwise. So I would ask that if you provide an opportunity for the gentleman to be heard, if you could come up.
And could you please state your name and address and speak in the microphone?
Sure. Brian Carr, address is 485C Route 1 South, Island.
And Mr. Carr, you were previously here. You understand you remain under oath, correct?
I do, yes.
And you previously testified in this matter. Would you be kind enough to state again for the record what your position is with Middlesex Water Company?
I am the Vice President of Engineering at Middlesex Water Company.
Okay. Why don't you explain as to why it is that you are seeking, not you specifically, but your company is seeking a differential in condition number 7 from 8 a.m. to 7 a.m. Excuse me.
Yes, like as you had said, our shift starts at 7 in the morning. We were hoping that we could time the first deliveries with our starting of the shift at 7. I will admit it's not a hypercritical event, it's our preference. So we are asking if that is an accommodation that can be made.
That's the answer, Mr. Chairman, members of the board. There was discussion at the last meeting as to what the request was at that time. You will recall that there was a full presentation. There was also no one present at the meeting from the members of the public that had any objections to this matter. So it's really up to the board as to whether or not you want to accommodate what is their standard, what has been represented to be their standard normal time at 7 rather than 8, which was stated during the course of the hearing. gentlemen and ladies.
Any
Up
comments?
to you.
Can we consider the question of proximity to residential properties and the noise level?
There was discussion about that, and the reason I mentioned it is because usually when there's a concern by members of the public, this was a noticed application, as you all know. And therefore, at least all people within 200 feet were noticed in the application at the last hearing.
Hold on.
And the fact of the matter is, to the best of my knowledge, and it's my recollection, and I'm perfectly happy to be corrected, but my recollection is that no one from the public was here and present either in.
Can I ask a question?
Sure.
I already, nobody who lives up there was noticed. Only the owners were noticed. They didn't share it with the tenants of Cedar Avenue.
Well, the municipal land use law is clear. They are required to end up doing property owners. And if it turns out that the property owner happens to be a multifamily, and then that satisfies the requirement.
But you said earlier that, you know, all people in proximity to the road had been given notice. It was just the owners of property in proximity.
I had said that that in accordance with the municipal land use law, notice had been provided in accordance with the municipal land use law. That's what they're required to do. They're not required to do anything more than that. So therefore, they've done it. If it turns out that they happen to have been to individuals that are in an apartment building, and the owners of the apartment building chose not to give notice to those apartment dwellers, that is their choice. That is not something that you as a board can require, because the municipal land use law is very clear. That's what the statute says.
Maybe.
So how far away is the road from the nearest apartment unit?
Right next to it.
Like 10 feet, 20 feet?
Much more than that, at least 100 feet. We're close to the tennis court, for sure. And I don't have the information with me, but I can find it for you relatively quickly. And it's not 10 feet, it's not across the street. There's several layers of trees between us and them.
Isn't the FedEx building right next to where there's a Wayfair every year?
The million square foot warehouse.
Yeah, that one. Isn't that right next to the apartments?
It's not, yes, it's next to they abut each other. But again, the building is set back, there's driveways in between, there is some buffer, natural plant buffer between the Segme property and the first set of apartments. It's not 600 feet, but it's not 0 feet, it's not 10 feet. I don't have the number in front of me.
Plus, the regime of trucks going in and out of the Segme property is pretty heavy, isn't it?
I don't know.
We've been assured that these won't be coming up Cedar Lane.
Right, they will not be coming through the Highland Park. They'll be part of our supply contract, as they are not allowed to come up through Highland Park from the Route 18 side, wherever that road. Right,
They would come from up through Edison.
yes. That's part of our supply contract.
I believe it's from Edison, right?
It is Edison.
It is.
I mean, the garbage trucks in Highland Park start at 7 o'clock. You know, and that's a lot closer to my house, for instance, than
Okay.
these guys.
There you go.
I mean, and the thing is, if the shift starts at 7, realistically, when is the first, you know?
Right, it's likely to be closer to 7:15 than 7, just because, you know, the place is manned 24/7, so if a truck shows up at 7, we can let them in. But
Yeah.
obviously, you won't let them in.
Wayfair is a 24-hour facility, I think, right?
I would assume so, but again, I don't know.
What kind of trucks are going to be going up this road?
Semi dump trucks with the large bins, they're gonna be hauling charcoal, essentially, granular activated carbon. So hopefully they'll be closed tanker, not the tank trucks, but more of an enclosed box truck, if you will.
All right, do we have somebody who considers this a significant change in memorialization, this time change? Or do we say that this is a minor change and we could vote on it with an A vote and then it's part of the records and you change it afterwards in the
Yeah, in the resolution.
with the 24-hour nature of the Wayfair trucks going in and out, it seems de minimis. I would move that we allow it.
Is there a second to that motion?
I'll second.
So,
I do think, Mr. Chairman, if you would be kind enough, I think it's appropriate to have a roll call.
okay, let's do a roll call
And
then.
by the way, what I think I'm hearing is that you're agreeing to memorialize the resolution with the modification of going
Or are
condition
we-
number 7 from 8 o'clock.
a.m.
until
Oh, okay,
0.
okay, I didn't understand that yet.
Yeah,
So-
and I wanted to be clear,
Right.
so that way we only have to have one
Two,
motion.
Okay.
Yes, Rob.
Okay, so we are now memorializing the resolution with that change from
Yes.
7, from 8
And
to
I'll
7.
make sure a copy goes to Maureen,
Okay.
as well as to the attorney.
We have a motion and a second, so please do the roll call.
Mr. Fector,
Oh, sorry, Chris?
So we changed also finding of fact, on page number 5. Last paragraph.
Page number 5, Chris?
Yes. Page 5. It's the last paragraph, Mr. Cancy testified that all exterior lighting will be night sky compliant, lighting will be used only when needed.
Oh, yeah.
in nighttime conditions and would only ordinarily operate during the facilities and business hours of operation, 8 AM to 5 PM. CDG, that's 7 AM as well.
Well, and very good to catch that. However, that is my recollection as to what the testimony was.
Right.
So I'm going to be suggesting that not change. It is what the testimony is. However, the board has the right to make a condition independent of the testimony, and that's what the board, at least that's what the motion has authorized.
I'd like to amend the motion to include the lights. We don't need them driving down the road in the dark. If it's a dark stormy morning.
You mean move that to 7 also?
Move that to 7 as well.
Thank you, Chris.
Okay, so that's fine.
so we're leaving page 5 alone?
No, we're
No.
changing it to 7.
Okay.
And I'll make that change as well.
Now we can do the roll call.
1 second, 1 second. Mr. Fector,
Yes.
Mr. Pheasant,
Yes,
Mr. Holsapple,
Yes.
Mr. Rothberg,
I think I should abstain because I was not here for the original.
That's correct, you should.
Mr. Winfrey,
Abstain.
Mr. Hofer,
I need to abstain myself too.
Okay,
I wasn't here.
Ms. Walsh,
No.
So then this has not passed.
so what was the vote? How many yeses?
3 yeses, 2 abstains, 1 no. I'm sorry, 3 abstains, 1 no.
Okay, so it passes.
It passes with.
Yes. Thank you very much for coming.
Thank you. Can I just say, we will continue to try to be a good neighbor for Highland Park, and we will listen to any feedback you guys have going forward with this new road.
Thank you.
Could you explain how the quorum rule works? Is it the quorum of the board is here or the quorum of the board votes?
Abstentions generally go with the majority. So therefore, it ends up being a situation where, at least for those who voted in favor, it was, did you say 3 in favor or
Mhm.
3 in favor,
3.
1 against? But then you had abstentions, which generally end up going with the majority. But nonetheless, even if you take that out, you still have a 3-to-1 vote, which is in favor.
But that's not my question. My question was regarding what constitutes a quorum.
Of the zoning board,
Yeah, is it a
4
quorum?
members.
Oh, 4?
Mhm.
Oh, we got it then. Okay,
And then we got it.
thanks.
But even if only 3, think about, but if we had 4 members and 1 abstained, then there 3 yes votes, is that not enough then?
No, okay, let me explain. very
We need
quickly.
to understand this, that's what I'm asking.
That's fine. The reality is that the quorum is for purposes of taking action by the board.
Mhm.
It is not a question of whether or not you had a quorum to vote in favor. Like, for example, there could be a situation, and I've had this over the years, whereby, and the courts have agreed to this, that you ended up having, let's say, a resolution that was approved in December. And because things got screwed up in that particular town, the people that were there in December, the vast majority of them were not there in January. So the only people that could end up voting is one person. Theoretically, one or two people. Theoretically, that is enough. That's not a quorum under any circumstances, not a quorum for the planning board, the zoning board, or land use board. It doesn't matter because the quorum doesn't affect the voting in terms of a memorialization.
Okay,
It's just a question of what the vote is.
okay.
And in this case, the vote was in a majority.
I will leave the lawyer. All right.
Thank you for that.
So we're done with that. So the second item on our agenda is the memorialization of a resolution Z 2026-02, the interpretation of section 23 of the zoning ordinance of the Borough of Highland Park. So we all were able to read it. Any discussion on that resolution? We do remember that meeting.
The Dorothy.
Yeah,
Yeah.
But Judge McCoskey has ruled against us.
He's not ruled against,
Hold on.
he's not ruled against you. He's ruled against the defendant in the matter. So
He had a different opinion than
he has a
us.
different opinion, and he's ruled against the defendant in the matter. I don't think that changes your vote whatsoever. You have voted based upon the facts that came before you. That was your opinion. I think that in my legal opinion, that whatever Judge McCluskey said is quite frankly irrelevant to the action that you took. Now, could there end up being further legal action between the litigant and the applicant? I suspect there could be. Could there be an appeal of Judge McCluskey? I suspect there will be. I don't know that, but I suspect there will be. Could there be other actions that are being taken? Maybe, but I don't think it has any bearing upon what you folks did at that meeting. You voted in favor of the determination that you made. The resolution, unless you have questions about the language of it, it is clear that you ultimately determined that it was final building.
Yeah.
So that's, I don't think McCluskey, with all due respect to McCluskey's opinion, it doesn't affect you or your actions that you took back on July the 7th, 27th.
How does it affect the applicant?
That's his problem.
Okay, so if the borough says you can build, but the court says you can't, is that, I just want to understand, I think we need to understand the concept.
That's an interesting situation. I suspect that there may very well be further action by the plaintiff in this matter, taking further action against, not against this board, but against the building department or any other action saying that you have to halt it because of the action taken by the judge. That will probably be litigated by the applicant and see what ultimately happens.
So the applicant could sue our zoning officer for misleading them. I mean, they put themselves in, they got loans, they built things. There's some harm. They seek a remedy.
I do understand that, but it is a very unique situation. I will be happy to advise you of that fact. But if I look at it from a legal viewpoint, the zoning officer took the position, and then there was an interpretation, and then you ultimately found that it was part of the building. So I don't think that the gentleman, and I'm not sure I can pronounce his name, but nonetheless, the gentleman who's the applicant, I don't think he's going to have much of a chance to be suing the town, because the town has been consistent in its position. It is only the court that is taking the position that it is an accessory structure, blah, blah, blah. So I don't think there's much of a chance. Well, anybody can sue anybody, as you well know. But do I think it's going to be successful? In my humble opinion, I don't think it will be, because the zoning officer and the zoning board have taken the same position. So it hasn't harmed the applicant at all. It's really the court that has done something, and I don't think he's going to be able to sue the court.
Thank you.
And if he does, that'll be interesting, another unique circumstance.
So currently, I'm sorry.
Go ahead.
Is the application restrained by the court order?
I really can't answer that question, to be honest with you, because I've never really had a situation whereby the matter was litigated during the course of an application, and then the court came out one way and the A board came out a different way. So unless there is a specific restraint that's contained in the order, and I was just given a copy as I was walking in, I don't know that it's automatically restrained. I think the plaintiff is going to have to take some further action to implement that order by Judge McCluskey. Now, that may very well cause an action being taken by the plaintiff in this matter against the building department and or zoning officer.
So was this board's decision revealed to Judge McCluskey? Do we know that? That has nothing to do with us, but I was
Yeah, I don't know that I know the answer to that question. I was not involved in that litigation, and I was not privy to any information about that. I know at the planning board, there was some off the record discussion about what may or may not have been said. But since I was not there, I'd rather not get into speculation as to whether or not the court knew or didn't know. I just can't answer definitively. That's good.
Interesting.
This is a very interesting situation. It'll be interesting to see how it all plays out.
They list us as a defendant. On the front page, it says Highland Park, and the list of defendants.
It lists Highland Park, not the zoning board of adjustment. So,
Oh, yeah, okay, yes. Mhm. All right, whatever. Do we do a roll call? Do I hear a motion? Do I hear a motion?
Just one thing, so I think what you're saying is, it makes sense for us to complete what we started.
not only does it make sense, I think you're obligated to do that unless you find certain language, that is not in compliance with what transpired at that meeting. What transpired at the meeting is you made the decision. If for some reason, Cliff in his transcription, I've always said, excuse me, that the resolutions are prepared by the attorneys, but it's not the attorney's resolution, it is the board's resolution. So if you have some issue as to some bit of language or something of that nature, then you have the right to change it. But other than that, can you suddenly change or not memorialize it? Can you otherwise change your decision at this point in time? Respectfully, the answer is no to both of those cases. And by the way, you could end up having yourself in a bind because there is a provision in the municipal land use law that says if you fail to take the action within a prescribed period of time, then the applicant can come in and require you to do that. And then you got to pay the applicant's attorney's fee. You don't want that to happen either.
On that note, do I hear a notion to approve, to memorialize the
resolution?
The resolution,
Mr. Chair. Before you call the vote, I just want to clarify. So I abstained on the last matter because I was not here for the hearing and I did not vote. So I think I'm not allowed to. So.
Were you here for this matter?
No, I was not. So it's going to be the same kind of thing.
Same kind of thing.
But is it an abstention? Is that the correct vote? Because did we just take two votes at once on the other application?
No.
One on an amendment as well as?
It was a singular vote to amend and to memorialize it. I consider that a singular vote.
Okay.
All right. And you are technically the three of you, well, I shouldn't say three. You are recused. You really didn't abstain. You were recused from voting because you gotta keep on remembering the microphone. You are recused from voting because you were not here. Therefore, you're not allowed to vote on it. Wolfer was also not allowed to vote on it, so he was recused from voting.
Just for the board's sake, we could have listened to the tapes of the.
No, you couldn't.
We could not.
No, absolutely not. If you did not vote in favor of the action, even if you had been here, listened to the whole thing, and then voted no, you would still not be eligible to vote because only the affirmative votes would be eligible to vote.
So the circumstance of listening to the tapes of a meeting you missed is only if it's a continued meeting, which is not a final vote?
Correct. So if it turns out that this meeting has gone on for 3 meetings and you missed the first one and you listened to the first tape, and you listened to and you were present the last 2, when it came to the vote for the determination, then you're all set. But once you miss the vote, you're out. You can listen to all you want, but it's not gonna do any good.
Thank you for the clarifications.
Any more requests?
I'm just not sure. Should I change my vote on the last matter to recused?
It's gonna be recorded as recused. The people that were not here are gonna be recorded as recused.
Thank you.
You're welcome.
Okay.
I'll make the motion to memorialize as written.
I will second it. I thought it was an excellent job.
So do the roll call, please.
Mr. Factor,
Yes.
Mr. Pheasant,
Yes.
Mr. Holzapfel,
Yes.
Mr. Winfrey,
Yes.
Mr. Hofer,
Yes.
Ms. Walsh.
I recuse myself. I wasn't here.
Okay.
Thank you for that. So we have one more matter on the agenda. Any other correspondence or reports that we have? Anybody from the public? There's nobody from the public here. So that section is closed. So our next item is to other business and work session, which is on the 2026 rules of order, which you have all received. And it is I think it's just an overdue change to how do we deal with online meetings, or Zoom meetings. And interestingly, our opening section of the agenda already takes that stand. It's not in the, so just to make clear that what we're gonna vote upon, it is on page, go through, page 5. If we go to that start page, that
The modifications were on section 4.05. By the way, this was a memo that I had sent to everybody, well, sent to the secretary and then distributed to all the board members in March the 30th.
Yeah.
Obviously, that's a long time ago. It was a combination of not having meetings and then I think you had some very busy meetings and you didn't, get into it. But anyway, what it's now saying is members of the public who wish to ask questions or to provide comments through testimony regarding applications for development shall be required to be physically present at the meeting. Questions and comments for all other matters will not be authorized through the Zoom format. And the reason for that is.
Where is that? I'm sorry, I was reading a different spot.
we are on a different page here, like
Wait, section
maybe these
3 or
numbers have
section
changed too.
Oh, maybe.
Where are you?
Well, basically, maybe let me just check. 405. Oh, that's, oh, shoot.
It's a different section.
Yeah, maybe.
302, is that the first change?
302 and then 308.
It's 302 and 308 that has our changes. If you want to check
Maybe
those,
that's it.
here we go. That's it.
Okay. But it's, I believe it's
The same thing.
Same language. So, and the rationale behind that is that applications for development are I don't want to say that in more important than others, I mean, but they are. And therefore, if it turns out that you are seeking to make a determination on the record, and sometimes, I'll be honest with you, I'm not a big believer in technology, but that's just me. I recognize it's here and it's a lot better than what it used to be. But the fact of the matter is that the sense, at least at the planning board level, was that if you're going to end up making a record and you end up having people that are usually objecting, most of the time it's an objection, although there are some times when you end up having people that come in and support the application. If they're concerned enough to make those comments in an application for development, they ought to be here and be present, so that there can then be legitimate cross-examination of that individual, should that be necessary, either by me as the board attorney, or by the applicant's attorney, or by anybody else who needs to have questions. So that was the rationale behind it. I think it's a good policy to do it that way. If there's other comments, like for example, if it turns out you always have a section where it's open to the public. Not that they're less important, but, they're not related to a particular application for development, which is a defined element of the municipal land use law. But if you have somebody that comes in and wants to talk generally about something, and if they decide they don't want to get off their couch and just do it by Zoom, the sense is that that's a different issue. That's not there's not such a need to be present. So that was the theory behind it.
I'm slightly confused. I apologize.
That's okay.
Are we talking about 3.02 or are we talking about something else?
It appears as though from my memo, things got changed a little bit. I know that the chair had made a couple of comments and maybe as a result of that, and I agree with.
Are we talking about the proposed rules that have red lines in them or are we talking?
Yes, we're talking about red line rules, yes.
Okay.
Section
So,
3.0.
And 5.07 on page 11. Yep, this is
I'm
what you're
sorry.
talking about. If you go to page 11 on this copy,
page 11.
page 11, and there's
On the
5.07,
red line.
5.07. Okay, yeah.
and that's exactly what you just said.
Right, so you were discussing 5.07.
Yeah,
And that is a
I-
substantive issue. That's more than procedural, I understand.
And I apologize for having the wrong number. That's because apparently there were some changes and I didn't update my memo. I just simply made those changes.
So 5.07 is in reference to actual hearings on cases before the board.
Yes.
And then 3.02 is just for like random stuff about the,
Yes.
people come in and say it's shameful the way you guys behave, that kind of thing.
I don't think
Yeah,
that's right.
That's true, yeah.
No, the 5 is.
So we allow
is-
that over the Zoom.
Yeah.
Oh, actually, I think the change that we didn't do, it's because we don't, we do master plan amendments, yes.
Is this a problem we have in our town? Because I could see that in some circumstance with some volatile applications, a massive town where there's, right now, we don't have to deal with the objectors who show up, right? Somebody could organize 1,000 objectors to stall a meeting for
Right.
years, right? If it's all online.
Well,
That's the fear?
actually, I've had situations like that, maybe not 1,000, but I've had at least several hundred at meetings. And when that happens, then what happens is that the municipality has to take an action to accommodate that. And that means it's not going to be held at this facility. It's going to be renoticed for the local school that has an auditorium. And I've had that situation happen on any number of occasions.
Even without online objectors, you're saying, or you're saying it's
No,
particularly.
I'm saying if there are, I'm not gonna use 1,000, I've never had that, but I've had at least 300 people show up at a meeting. And because there was an anticipation that there was gonna be a large group of people, the meeting was changed from the municipal building, which are generally this size, they're not that big. So instead, in that particular case, there's several of them, they usually end up being at a school auditorium. In one case, I remember it was the high school, in another case, it was the I can't say grammar school, it dates me, the middle school and primary school, or some other facility that will accommodate a larger number of people. So that's what ends up happening. So, and that way it is accommodated, and if it turns out that there are 150 people and they all want to be heard, they're here and they can be heard. Now, has it happened here in Highland Park? Not during my tenure.
We had some big ones,
That may,
like the Home for Veterans. This room was full, if
Okay.
you remember, right?
Which one?
The Home for Veterans that was in the church, like when that was changed, that room was packed.
yeah, and that may be before me, so I don't remember that. So does it happen often?
No.
No, but the language doesn't create, in my opinion, doesn't create a problem, because what it's doing is it's saying, you gotta be here, and therefore the municipality has an obligation to provide those accommodations. And I'm sure that there's an accommodation someplace in this town. You said that the church is one, there may be, the school, I'm assuming the school.
Community center, you like.
Whatever.
So is this a discussion on this, or is
If you'd
this a
like.
presentation?
No, it's really just a recommendation. This is what this is what the planning board did. And all I was suggesting back in March or whenever it was back in February, March, to simply try to bring the rules into unison. And that's.
I understand that,
That's all.
because it's a substantive issue. It'd be odd for two boards to
Correct.
have different substantive rules.
Exactly right.
But I'm a little bit troubled by this. I don't know, because it essentially, you could have somebody who's disabled who would be incredibly difficult for them to come in present. But if we allow them to testify
Well,
on Zoom like we did during
again-
COVID.
Again, respectfully, if you're going to end up having an alternative facility, the vast majority of the alternative facilities within municipalities, in addition to this municipality, I assume, ends up having handicap accessible facilities. I've never been to your school. I would doubt very much if they are not handicap accessible. I would doubt very much if the church 18 years ago, whatever it was, where they had 150 people.
No, the meeting was here for
Oh.
these people. It was about veterans
Oh,
in
I
the
see.
church.
So-
The buildings, accessibility is only one part of it. They also need to be able to get transportation and all of that. And I think just having a clause where it can be like open and you can ask like good faith was made to try to come, but there's outside circumstances that require this person to be able to testify online. I think that is more than agreeable. If they made a good faith effort to come in person, they really just can't. For medical reasons, ability reasons, whatever. I think that's reasonable, and especially given what everything was with COVID and no one being able to be in person. I think to have a hard and fast rule just like this that absolutely no one can testify unless they're in person is a little bit too tight.
These are your rules, not mine, okay? And this is what the planning board thought was reasonable. This discussion with regard to disabled individuals was not something that was brought up. You want to bring it up, it's not inappropriate to bring it up. If you want to change the rules to accommodate, to say that people are required to be in person unless they have a handicap that adversely affects their ability to attend, that in and of itself creates some problems, because how do you verify that? I can have
Good faith.
a broken leg at that particular moment and say, well, I can't come because I got a broken leg, But nonetheless, you have the right to put in some language, and if you do want to put in language like that, I think we need to think about it to try to make sure that it is accommodating the concerns that you actually have, and will not turn into something of a farce as was suggested, that somehow you get a bunch of people who are adamantly against it, and they end up talking to their neighbors and say, you don't come because you got a disability, and they sort of manufacture a disability. You need to make sure that you are careful in your craft. And if you're going to do that, I would suggest you let you guys think about it a little bit. I need to think about it a little bit, and then we'll just defer this again for another month. It's not the end of the world. We've already deferred it for 5 months. It's another month is not to tell you.
Do we have any pending applications?
Have your
We do. I just want to say, from the perspective of the board attorney or institute, thank you. I think that this is exactly what you should be advising us. I just think that as Highland Parkers, we're a little bit different sometimes. And
You can't make me say that. You can't make me go there.
Does anybody know how school board meetings are held? Do
What
they
do you
have,
mean? I assume they're held in the school.
no, but
School auditorium.
do they allow comment on resolutions?
Don't know, I have no idea. I guess.
Does anybody here know?
I think a lot of them, you have to recognize that what you guys do may be different from what Edison's school board does or others. So it's a matter of what the rules may say. There's nothing uniform about it necessarily.
But particularly because the applications we're considering are not furthering a public benefit, it's some private homeowner or property owner who's trying to do something with their property that our current rules don't allow.
Yep.
Right? So the whole thing is not in furtherance of the grand public purpose other than providing a forum.
Mhm.
Can we make exceptions for disability at the chair's discretion?
Well, again, yes, again, I understand the thought process, okay, and I'm not disagreeing with it. I'm just simply saying that it is reasonable that you're thinking about that. I would just like to have the opportunity to think about the kind of language that would be appropriate so that it doesn't turn into, and I use the word farce, and I mean that in not a pejorative sense, just having a situation as was suggested, that, you know, suddenly there's this really controversial application and a group of 300 people, you know, or whatever, a group, or for that matter, a group of 5 people stir up 300 people, and then they tend to use that language as a mechanism to delay and obfuscate.
Yeah,
That's my favorite law firm, delay and obfuscation.
Microphone.
I guess I'm still concerned about the idea of creating 2 different rights of objector based upon status, based upon their ability to show up in a room at a certain time. And that both could be offering something valuable to the board and to the application. So I wanted to go back to like, you know, during COVID, didn't we start meeting remotely, or did we never meet remotely?
Well, I mean, the vast majority of boards in the state met remotely.
Right.
You know, let's be honest, the zoning board generally does not have a heavy agenda. Does that mean that for the 3.5 to 4 years of COVID restrictions, really, do I think you had no meetings? I kind of doubt that, but I understand.
Right. So I talked about disability because I'm coming off of a year of disability myself, and it's been difficult for me. And I'm trying to appreciate what it's like for people to be disabled and to be constrained. And even though rooms are handicapped accessible and stuff, it still doesn't make it easy for people to show up.
Mhm.
But did we address it all?
No, keep that by you.
Did we address in our rules at all whether I can vote on Zoom, whether I can hear an application on Zoom? Do our rules talk
No,
about that? So it's
It does not.
So do we have a stance on that? Do any of our boards allow remote participation?
I don't know what the governing body does, and it's silent in regard to the planning board. And I think that most towns generally expect their board members to be present. Certainly, if you have a controversial application, because you know you're there and you're supposed to be not only you're supposed to be viewing the record. Well, the record includes not only the testimony that you're getting, but also the exhibits. And sometimes those exhibits become very difficult to observe, even if you're here, let alone through a Zoom call. So I think that's why most board members or boards that I represent, all the boards that I represent, and I suspect most boards around the state prefer to have their board members present when they're dealing with applications, whether they're controversial or not controversial.
So all of these are not talking about that. They're assuming on-site presence of members.
Yes.
And it's only addressing the ability of the public to view and how they can participate.
Yes.
That's what we're addressing.
Yes, and it's been my experience that all of the boards that I represent will expect board members to be present, unless it's like, for example, I've had any number of times when, like, for example, if today you only ended up having no applications, but you had memorialization, you know, that could easily be done, I think, on a Zoom call, and it's been done because you're not observing anything. You already have a copy of the resolution, and you can hear and see what people are saying about that resolution. So it becomes less of a concern. But on an application, you're dealing with more than just talking. You're dealing with usually physical pieces of evidence. It sometimes can be hard to see.
So we turn to 3.02 for 1 minute.
Yeah, sure. Which page?
Page 5.
Page 5, okay.
Yeah, thank you.
Are we allowing members of the public to participate virtually or not? we're allowing them to view it or to ask questions?
It says, let me just read it for the record. The board authorizes virtual format for members of the public to participate in meetings.
So that's telling me that we're allowing them to ask questions.
Okay, let me just go on. For matters not involving applications for development, master plan amendments, or redevelopment hearings requiring adoption by the board, members of the public may ask questions and make comments on all other matters utilizing the virtual format. Preference for participation by the public in Zoom is to utilize cameras. However, that will not be a requirement for if an individual member of the public is unable to be viewed on camera due to technological reasons. What that's really saying is that, again, because the nature of those particular exceptions are of a higher matter than just a general discussion, therefore, they are required to be present. If you have a general matter, then you can be on Zoom. Now, I know that there are a lot of boards that I represent that don't like the idea that somebody's on Zoom, you can't see that person. This is saying, well, if the person has a bad connection or whatever the case may be, and in some of the towns that I have, believe me, there are connection issues, and I run into them. But that's what it's authorizing.
So this conversation would be if people could participate on
Yes.
Zoom.
Yes, absolutely.
And the real beef is in point 3.8 on the same page, because that says appearance, for the record, the applicant and any objectors shall appear in person or through attorney admitted to practice of law in the state of New Jersey. No cooperation shall be heard except through counsel.
And that's by state rule. That's not even something you can debate.
So do we need to put it in our rule? What if the state law changes and we have to change our rule?
I tend to be kind of a boot and suspenders kind of guy.
But
that's only about corporations being represented, right? But individuals do not.
Right.
But we are saying here that objectors have to appear in person.
That's
No.
what we're saying. That's
No.
exactly
Well,
right.
we're saying the applicant and their consultants, its consultants have to appear in person. And we're saying that if there's an objector to an application for development, they need to appear in person. Now you're raising the issue of a disabled individual. That's something that if you decide you want to end up taking that into account, I would suggest that what you do is you table this matter for another month, which is not the end of the world, and then we talk about that. And I'll try to come up with some language that I feel reasonably comfortable with that is not going to be abused. And I know that Chris has been holding his hand up. Either he has to go to the bathroom or he has a comment.
I have a comment.
Okay.
As the board's considering, well, first of all, tabling is good ideas. A lot of good discussion on what should be, and should not be in the rules of order. One thing you should consider with regard to virtual participation is if the board is going to allow an objector or any member of the public to participate in the virtual hearing, you may want to also consider applicants and even borough, for that matter, to ensure that its application materials are accessible digitally, which means connecting to the TV through Zoom, so on and so forth, just like how I do for retelling presentations, which by the way, I still owe you this.
Yes, you do.
Sorry, that'll be tomorrow morning. But just to allow for someone in the public to see what's happening in the hearing, this camera may not pick up a black and white exhibit far away. So you may need to consider applicants to have a presentation available and shared through the Zoom portal. There's a lot of layers to this.
Your point is well taken. There are a lot of municipalities. As a matter of fact, I've been told one municipality in the Somerset Hills area could probably produce Star Wars. They have such technology. But the fact of the matter is that there are a lot of municipalities that are now saying that in addition to the paper copies, that they are required to submit a digital copy. And I don't think that's unreasonable. Even though I'm not a fan of technology, I do understand that that's an appropriate thing to do.
Only thing I personally feel a little bit uncomfortable is if we then have again a different ruling, different rules than the planning board.
Well, you're right, and I think that this if it turns out that this board decides they want to have some alternative language, believe me, at the next planning board meeting, I'm going to bring this up.
Okay.
And because the mere fact that they didn't think about it doesn't mean that it's not necessary, that that they thought about it and rejected it. They clearly did not.
Yeah.
You know, I do agree with you. I'd like to see things uniform, if possible.
So we can still function even if we table this.
Yes, absolutely.
So then,
Can I make a motion to table?
Okay.
I'd like to think about this.
and are we allowed to communicate in between with like that we share among the board text ideas, or are you giving us a real example?
Well, they're in, no.
I'm not a lawyer, so I'm asking.
Yeah, well, but I am, and my response is, one of the things that I have concerns about is the individual communication between board members. As you know, you are the ones that are supposed to be acting in a quasi-judicial manner. What does that mean? It's like judges. And it means that you are supposed to be relying upon what is in front of you as part of the record. So if it turns out that what I find, and I've had to, I don't want to go so far as to say admonish, but I am concerned about when I see all the board members having computers in front of them. Because I would like to think that what they're doing is they're taking the digital materials that have been submitted by the applicant and viewing them on their computer. That's perfectly fine. What I have seen, unfortunately, and I've had to admonish people, that while the application is being presented, they're going on the internet and typing up information that is not on the record. And are they relying upon it? I don't know, but I don't care. That's just not permitted. So that's a concern of mine.
Yep, good
So,
point.
And then getting to your specific question, you know, when you end up having conversations between board members, you know, can I stop two members talking about an application? No, I really can't. But God forbid you end up having a group.
Mayor, we're talking about,
change.
we're talking about proceedings, we're not talking about a hearing here.
Yeah, this is our rules.
These are our rules, so it's like, we're a committee.
Oh, yeah,
source, we-
that's fine. But I'm talking about, I thought you were.
But it's-
No, but I was asking if anybody of us has a text idea, how to, like, if you had an idea how to phrase it, if you could, could share this directly with you.
I thought you were talking about just a general concept.
No, about, we're not talking about.
But I am going to point out that, you know, if you do end up having an application that's in front of a board, because we have so much technology, you know, people have a tendency, nobody talks anymore, everybody texts. And if you have a group text, you have a violation, you potentially have a violation of the Open Public Meetings Act. So just be aware of that fact. So, and all of that's discoverable.
Well, we have a commissioner for universal access here in town. Can we ask their opinion?
Yeah.
I'm sorry,
The Committee for Universal Access.
I don't know what universal access means.
We have a commission for universal access here in town. Make sure that people with disabilities have access to our town.
Yes, actually, yes. So that's a good point. We can
Okay.
ask them for opinion, but if you would provide us a wording
I'll
for
try
the
to.
next meeting,
I'll try to.
and
Is this an extra copy?
that's an extra copy.
Perfect, thank you.
So we are tabling that matter. Do we have to vote on the table? Tabling that matter?
I heard one motion.
Then second-
There's a
who
second,
seconded?
and then I don't think you need a roll call, just a voice vote. All in favor?
Aye.
Any opposed? Good.
One more thing, I'm sorry, one more thing. At the beginning of the meeting, we had the discussion that that property owners do not regularly inform their tenants. Like we had this situation as a town that has a large number of tenants. I would just want to bring up the thought, how can, I know you cited the land use law. Is a town like Highland Park with a higher percentage of tenants, can we say that we require the
No.
landowner to do that?
No, you cannot. You are constrained by the municipal land use law. You cannot make them do more than they're required to
write
do.
your legislation.
However, I mean, the fact of the matter is that you end up having, you are required, in my opinion, well, I don't know about required, but all towns at this point have websites, and all websites, to the best of my knowledge, end up having subparts for the planning board, the zoning board, et cetera. And then agenda items are on the record, minutes are on the record, and those are things that maybe should be more publicized, because maybe a lot of people don't know that, but they should be on, and they become available for the public to be aware of what's going on.
Do we have any ability to like share that information with those tenants, like as board members? Like, do we have a role in information sharing?
If you want to end up going and saying something individually, can I stop you? Do I think that's an inappropriate statement to make? No. Do I think that you would be remiss if it turns out you ended up throwing out what would be a group chat or whatever they call it to 150 people in apartment A? Yeah, I think that's a problem.
Roger, how about Facebook? I mean, if you posted on, I'm from Highland Park, that, there's a hearing on the water company on Cedar Lane,
Yes,
that would be fine.
absolutely. And it should already be there. In other words, on the agenda, this agenda should be on the
Well, that would be the
website right
town's
now.
website, which I actually don't even know if it was posted. I don't.
Yeah. So I
into
mean,
the
it-
town
it-
website
yeah,
much.
yeah. So I mean, all of those agendas should be on the website right now, and they should be, set up in such a way that it's clear that it includes the fact that it's the name of the, like, sometimes you end up hearing a name, like, I don't, you have names and then you don't even know what they stand for. So it would be a combination of the name, the address, the lot and block, although most people don't know what lot and blocks are anyway. And just a short little statement as to, generally what it involves.
So posting in a Facebook group, good group text back.
No,
That's what I thought you just said.
no, I said if you wanted to end up making a phone call or having a text to an individual tenant to say, you know what, because you know Mary Jones who lives there, or you become acquainted with somebody who lives there, and you end up indicating to them that there's going to be a meeting, and if you wanted to do that, I don't think that's a problem. If you ended up getting a list of the 150 people or the 50 people or the 35 people that live in that apartment building, I think that's a problem.
That would be a Facebook post.
Because I think that you're going above and beyond what the municipal land use law provides for your authority. That's my opinion.
But it is not, so
You are-
because she's a board member,
She's a
was
board
there
member.
a
You are-
cat that was posting this stuff? Would it be okay?
With all due respect, all of you are creatures of statute. I hate to use that terminology, but that's what you are. So you do have restraints.
That's what I was asking.
Yeah, and that's what I'm saying. I didn't hear what you said.
But her cat could post it.
I'm sorry.
I'm sorry. Right, as board members, we have to.
You have rights and you have limitations.
Yep.
Just as, you have a situation, and I mean, I didn't think we were gonna get into this, but, you have an application before the board. You have a right to come before the board on your own to make that application. If you came to me.
As a
you
board
asked me-
member?
As a board member, and you had a subdivision a subdivision with a D variance that comes before this board and you're a member of this board. Do you have the right to come before this board? There's some question about that. There's some case law that suggests you are not a second-class citizen. You have the right to come and make an application, but maybe you ought to be making the application through somebody else, maybe your wife, maybe an attorney, maybe a planner. Those are the kinds of constraints that board members have. That's why you get the big bucks.
For change, not even.
On that note, any other comments or discussion points? Then, does anybody make a motion to adjourn the meeting?
I will.
I'll second.
So everyone in favor?
All right.
Meeting is adjourned.